All right, hello everyone, and welcome to our latest ALTA Insights webinar. I'm Jeremy Yohe, Alta's Vice President Communications, and today we've got a great webinar that will focus on a new rule that went into effect January 1st that requires many companies to prepare and file a beneficial owner information report with FinCEN. Before we dig into the presentation, I have a few housekeeping items gotta go over before starting. Just as a reminder, the webinar is being recorded. You'll get an email with a link to the recording tomorrow. You can always access all of our webinar recordings at alta.org/webinars. That's alta.org/webinars. And you can also download a PDF of the presentation right now from the handouts section in the GoToWebinar window pane. If at any time you do have a question, submit them in the questions box. We'll hold some time at the end for Q&A. Also, as a reminder, we are offering CE and CLE credit for many states. Credit is only available for those of you attending the live presentation. To meet state compliance, we'll have a couple of poll questions sprinkled throughout the webinar, so make sure you're paying attention. No multitasking or checking up on the Super Bowl advertisements from last night. And then at the end of the presentation, I'll post a link in the chat box where you can go and provide information that we need to report your credits. The link, I got a few other items here been updated on. The link will allow you to request CE, CLE. So follow that link, go to the Alta website, you'll have to log in. The link will be active for 72 hours. And let's see, to ensure you receive your credit, you add or update your national producer number and your license or bar numbers in the states where you're requesting credit. And then check the attendance certification box and click request credits. I will paste all these instructions into the chat box because I frankly forgot what to do. If you're not requesting credit, a non-credit certificate of attendance is available for print or download. All right, I do need to thank Certified for sponsoring today's webinar. And before introducing today's speaker, we have a short announcement or advertisement from Certified.
It felt like we weren't getting any support from the people involved in a real estate transaction. The banks were kind of hands off on that. It was just one of those things, who's doing something about this?
My team was so excited to learn that there was a software program that they could send these payoffs out so much quicker, so much more efficiently, and with that peace of mind security that there is insurance that is protecting these funds.
I would advise you to look into something immediately because the wire fraud is so prevalent. We are seeing so many different scenarios and ways that they are coming up with to infiltrate, get money, and divert, and you need to be protected.
Okay, let me change the settings here real quick, and then I'll introduce today's speaker. All right, I gotta try and make you the presenter, Jonathan. Here we go. There we go. Click, go. Boy, I think I fumbled the ball. All right, let me introduce today's speaker. Joining us today, we have Jonathan Wilson. Jonathan is Chief Executive Officer of the FinCEN Report, which is an online filing service for reporting companies that must file beneficial ownership reports under the Corporate Transparency Act. Jonathan is an attorney and corporate partner at Taylor English Duma. He has 31 years of experience in corporate, M&A, and securities matters, and is a former member of the Board of Governors of the State Bar of Georgia. Jonathan, thank you for taking some time to inform our members about the rule and helping them understand if they need to file a BOI report. And I'll turn it over to you.
You bet, Jeremy. Is the screen coming through okay?
Yep, sure is.
Fantastic. All right. Well, thank you very much, everyone, for joining us today. My understanding is that as title insurance experts, you're very much involved in transactional matters involving real estate. So what I'd like to do is give you a general overview to the Corporate Transparency Act, and then provide some very specific examples of real estate transactions that can be implemented. As Jeremy mentioned, FinCEN Report Company is my company. You can find more information about us at fincenreport.com. And inside the Q&A is a link if you'd like to get a demonstration of our software. Just click on that link and give us your name and email, and one of my colleagues will reach out to you to give you an idea of how you might be able to use fincenreport.com in your practice. So we're going to talk about the Corporate Transparency Act and some of the key vocabulary words involved, such as reporting company, the exemptions, what is a beneficial owner, and who is the company applicant. We're going to talk about what the timing rules are for when the reports are due. And then we're going to talk about indirect beneficial owners and how you figure out and report who those are if you are in a position of having to file a BOI report. And then we're going to give you some very specific examples about real estate transaction structures, and including some fairly standard developer structures, some structures involving 1031 swaps and opportunity zone investments. So if this is new to you, if you have not previously gotten an education on the Corporate Transparency Act, if there's nothing else that you remember the first sentence on this slide. Every reporting company that is not exempt must file a BOI report that will disclose 5 specific items of personally identifiable information, or PII, for each of that reporting company's beneficial owners. That sentence right there contains all the new vocabulary words that you're going to need to learn in order to deal with the Corporate Transparency Act. And I'm going to dig into what those are. If you have a company that was formed before January 1, 2024, that entity will not need to identify its company applicant when it files its report. Entities formed on or after January 1, 2024 will need to identify their company applicant, and we're going to talk later about what that is. After a reporting company files its first BOI report, it's done. It does not need to file every year. So it's not like your tax return. We're not going to file these over and over again. However, every reporting company must remain alert to any changes in its beneficial ownership. If there is a change, that triggers a 30-day amendment. The company must file an amendment within 30 days of the event taking place, or else it's overdue. In addition, after a reporting company has filed a first beneficial ownership report, if any piece of information applicable to any of its beneficial owners should change, such as their home address, their date of birth, or their identifying document, that is also something that triggers a 30-day amendment rule, and the reporting company will need to file an amendment that includes that new information. So any change in beneficial ownership or any change in an item of previously reported data for a beneficial owner, either one of those two things triggers the need for an amendment. It's important that beneficial owners, that reporting companies get these reports done on time, because the failure to file on time can result in a $500 per day fine. In addition, a willful failure to file or a willful filing of inaccurate or incorrect information may result in a felony conviction for the senior officers of the reporting company or the persons who were responsible for the false information. So that's your thumbnail overview. I'm supposed to pause now, I think, for a poll question from Jeremy.
Yep, Jonathan, quick poll question for everyone out there. Just, how's your business structured? Take a quick second, let us know. Jonathan, about half LLCs, a quarter are S-corps, and another quarter are corporations, with small amount being sole proprietorships and partnerships. So, all right.
Excellent. That is very helpful to know. So congratulations, all of you who are sole proprietors. You do not have to file. Sole proprietorships do not file under the Corporate Transparency Act. In order to be something that has to file, you need to be a reporting company. And the law defines reporting company as either a domestic reporting company or a foreign reporting company. A domestic reporting company is a corporation, LLC, or other entity that is created by the filing of a document with the Secretary of State. This can create some interesting edge cases. In the case of a general partnership, in most states, a general partnership can be formed without filing any document with the Secretary of State, but there are a few exceptions to that rule. If your state requires a filing of a certificate of partnership in order to create the general partnership, in those states, a general partnership would be a reporting company. Also, trusts are a good edge case. In most states, a trust is something created by private contract. It is not, therefore, a reporting company. One of the exceptions to that rule, however, is the Delaware Statutory Trust. A Delaware Statutory Trust is created by the filing of a document with the Delaware Secretary of State, so a DST would be a reporting company. Now, those are all domestic reporting companies, but the CTA also applies to foreign reporting companies. A foreign reporting company is any entity formed outside the United States that registers to do business in the United States by the filing of a document with a Secretary of State. So once again, it's that filing of a document with the Secretary of State that is the trigger that causes something to be a reporting company. Now, if you are a reporting company, the next question is, are you exempt? There are 23 different exemption categories. I won't be able to read them all here. You can see them on the screen. In general, they are things that are somehow subject to some form of governmental regulation so that the government knows who the responsible parties are behind the entity. At its heart, the Corporate Transparency Act is an anti-money laundering law. Government wants to know who are the ultimate beneficial owners of companies that today are anonymous. And in that way, the CTA tends to eliminate corporate anonymity. So if your entity is one that might be covered by one of these exemptions, you are going to want to crack open the regulations and see whether the regulations apply to you, whether the exemption applies to you. And by the way, when I refer to the regulations, FinCEN's final final rule on BOI reporting is found at 31 CFR 1010.380. If you just throw that into your Google search engine, you will come up to the government printing office version of the regs, and they are searchable and easy to find your way through those. So those are your 23 different exemption categories. If you are a reporting company and not exempt, then you need to file. The only question is going to be when. If you are an entity that was formed before January 1, 2024, you don't need to worry about who your company applicant is. If your entity is formed on or after January 1, 2024, then you will need to identify the company applicant. Company applicant is a term that we have never used before. It was invented whole cloth for purposes of the Corporate Transparency Act. And the idea, once again, this being an anti-money laundering law, is that the regulators want to know who is it that formed the entity. So if they can't find any other beneficial owners who are responsible, at least they can figure out who it was that formed the entity. So the company applicant will always include the individual who directly files the document with the Secretary of State that either forms or registers the company. Notice it doesn't matter who drafted the articles of organization, who had the idea to do it, who was primarily responsible for it. It's the person who directly files the document. So at a law firm, if a paralegal is the one who directly files with the Secretary of State, it would be that paralegal individually who is the company applicant, not the law firm as an entity. If the paralegal picks up the phone and calls a corporate service provider and an employee of that corporate service provider directly files the document, it is that individual at the corporate service provider who is the company applicant, not the paralegal who gave the order. Now, if more than one individual is involved in the process of preparing the document for filing, then in addition to the person who is the one who directly files the document, the reporting company must also identify the individual who is primarily responsible for directing or controlling the filing. Now, before FinCEN clarified its FAQs in early January, a lot of the law firms were doing backbends and trying to come up with ways that they could somehow contract out of being a company applicant. I even saw some law firms trying to modify their engagement letters so that the client would say that the client was the person who was the company applicant. None of that stuff works anymore. If you're curious, you can go to FinCEN's FAQ E5 that was updated January 12, and it gives you several very specific scenarios about how the client can call the partner can give it to the associate hands it off to the paralegal, and then the paralegal directly files and figure out who out of all of those individuals is the company applicant. But the bottom line is that the company applicant will always be the individual who directly files the document, and if more than one individual is involved, it will always also include the person who was primarily responsible for directing or controlling the filing. Now we're zipping right along here. I'm trying to see, do we have any questions in the questions folder? I am not seeing any. If you happen to drop any questions in the question folder, I'd be happy to respond to those as we go along or at the end here.
Hey, Jonathan,
Right, so if you're a reporting company,
hey, there are a couple questions. I don't know. I'm not sure why you can't see them, but if you want to tackle a couple of them, they are really pertinent to kind of the discussion of companies that have to exempt. Since people are in this title insurance space, the one block you had that were exempt insurance company, and so that's a question is, would a title insurance company be considered exempt from reporting, or do they need to report?
Sure, and it's going to the answer to that question is going to depend on the legal status of the title insurance company. You would want to crack open the regulations and go to the exemption for insurance companies. In fact, I'm going to go ahead and see if I can't find it here. Yeah, unfortunately, you may need some legal help with this one. The exemption says that an insurance company is an exempt if it is an insurance company as defined in Section 2 of the Investment Company Act of 1940. It's a highly legalistic answer, and without knowing more of the regulations that govern insurance companies, I can't answer that one off the top of my head.
Well, we've got lots of questions around who has to report, so maybe we'll table that for a second and get through the rest of the presentation, and we'll circle back here at the end.
Sure, let's do that. Okay, so if your reporting company is not exempt and it needs to file, it needs to identify who are its beneficial owners. An individual person is a beneficial owner if that individual either owns 25% or more of the ownership interest of the entity, or if that individual exercises substantial control. Now, notice a beneficial owner must almost always be an individual. The only exception to that rule is that if another reporting company that is itself exempt is the owner of your reporting company, you do not have to inquire of the exempt reporting company who are its beneficial owners. Instead, you would just provide the full legal name of the exempt reporting company when it is itself an owner, a beneficial owner. With respect to everybody else, though, we're either applying a percentage ownership test or a substantial control test, and you're a beneficial owner if you trigger either one of those two tests. Unfortunately for everyone, this is not at all an easy question to answer. When we're calculating percentage ownership, FinCEN has actually given us, in the regulations here, some very precise rules on how we're supposed to be calculating who is a beneficial owner. First, when we have securities in a reporting company that are convertible or subject to vesting, we treat all the calculations at the present time as if any options or similar convertible interests of the individual have been exercised. So an individual that owns stock and also a convertible note, you would treat the convertible note as if it had converted into stock and then apply the percentage ownership test. Next, you have two different means of calculating percentage ownership depending on the tax status of the reporting company. If the reporting company is one that is taxed as a partnership for federal income tax purposes, then percentage ownership is measured in a rather peculiar way that requires us to take all of the outstanding capital and profits interests of the entity and the capital and profits interests of the individual and compare those two to see what the percentage is. Now, my colleagues who are tax lawyers hate this language because they say, Jonathan, we never look at capital interests and profits interests and then add them together. That's just not how partnership taxation work? And my answer is, you're probably right. Unfortunately, the good people at FinCEN who drafted these regulations, I don't think that they were tax lawyers. And this is what they wrote, so we're rather stuck with it. So somehow we need to calculate what the total outstanding capital and profits interests are, and then allocate them amongst all the different owners, and then see among those owners who has 25% or more. Alternatively, if the reporting company is a corporation and it is taxed as a corporation, and this would include S-corps, by the way, we have to apply what I call the corporate capital rule. And that is that an individual is a beneficial owner if that individual has 25% or more either of the total voting power in the corporation or the total combined value of the ownership interests in the corporation. Again, the phrase total combined value is not really a concept that we have in the law before the Corporate Transparency Act came along. It's not a tax concept. The idea is that you take the total distributable value of the company as if it were liquidated and then divide it up amongst all of the owners of the company, in this case the corporation, and see who has 25% or more. In that instance, I think it's pretty much the same thing as the partnership capital rule, requiring a hypothetical liquidation. Now, in both the partnership capital context and the corporate capital context, it's possible that you could reach an outcome that is not reasonably certain. And that would be one where you have a distribution waterfall that requires the calculation of value based on a certain amount. For example, an LLC that has multiple levels in the waterfall where investors first get their contributed capital back at one ratio, and then someone else gets a percentage of the distributions at a different ratio, and thereafter everyone splits according to a different ratio. In that instance, unless you know the actual liquidation value of the company, you really can't determine what percentage anyone will get. Because if it's $1, it might be one percentage. If it's $1 billion, it might be a different percentage. And that same outcome can apply whether it's a partnership or a corporation. In those situations where you cannot determine what the percentage of distributions would be, again, the FinCEN regulations give us a fairly straightforward rule to apply, and that's what I call the fail-safe rule. And what the regulation says is that if the facts do not permit you to calculate percentage distributions with reasonable certainty, and that's the test, reasonable certainty, then we're going to treat as a beneficial owner any individual who owns or controls 25% or more of any class or type of ownership interest. Okay, now what's a class or type of an ownership interest? Well, here I think the prudent test is to treat each level of the waterfall as if it is a different class or type of ownership interest, because people get different percentages at different amounts based upon their position in the waterfall. FinCEN, the regulations don't go much deeper than that, and the FAQs don't go much deeper than that. So for those of us who do LLC operating agreements in the real estate context, they almost always have multiple levels of waterfall. And I think for the vast majority of those, we're going to find ourselves applying the fail-safe rule so that 25% or more of the ownership interest is 25% or more of any level inside the waterfall. But all of this only has to do with your ownership percentages. When we're calculating those ownership percentages of a reporting company, again, if one of the owners is a non-exempt reporting company, you ignore it and you look up the chain of ownership to figure out whether any individuals have 25% or more. If the owner that has 25% or more is itself an exempt reporting company, then you do report the legal name of the exempt entity. If an interest in a reporting company is owned by a trust, we have a special rule that applies to trusts. We're not going to dig deeply into that in this presentation. I actually have a trust in estates presentation where we do that. Just know that in the case of the trust, the attributable individual will either be the trustee, the grantor, or the sole beneficiary of the entity, depending on the terms of the trust instrument. And then finally, if there is any other sort of arrangement in which multiple individuals somehow share or jointly have ownership, we have guidance in section 380D2.2 that says that we treat them each as if they have an ownership stake. And then finally, there is a twist involving married individuals in community property states. Now here, I think FinCEN didn't do the greatest job of giving us specific guidance. FinCEN actually didn't even talk about the idea of community property interests in the beneficial ownership regulations. Instead, all they gave us was the guidance in section 380D22, which says that it's possible for multiple individuals to all be beneficial owners of the same ownership interest if they have a joint and undivided interest. Well, in about 9 different states in the US, there is some form of community property interest. And in those states, if a married individual is the owner of the ownership interest, it's quite possible that the married individual's spouse also has a joint and undivided ownership interest in the same ownership interest in the reporting company. Now, when that situation presents itself, that's not necessarily the end of it. Depending on the state, the ownership interest might or might not be community property, depending on when and how the interest was acquired. There are also some situations where spouses can have agreements between themselves, such as a prenuptial agreement or a power of attorney, that causes the ownership interest in the reporting company not to be joint and undivided. It all gets quite complicated. So just be aware, if you have individual beneficial owners in your reporting company who are married and who reside in one of the 9 community property states, you are going to have to inquire more about the marital status and the nature of the ownership interest and how it was acquired. And you might even need special counsel in the state in order to apply its community property laws. So I'm going to pause for just a moment and take a drink here. All of what we went through was just to figure out who owns 25% or more. Owning 25% or more is only one of the 2 prongs of the test of being a beneficial owner. A person who owns 25% or more is a beneficial owner. But we must also count as a beneficial owner any person who exercises substantial control over the reporting company, even if that individual owns nothing of the reporting company. In other words, you can be a beneficial owner even if you are not an owner. So what does substantial control mean? It does not mean that you have the power to do whatever you want. It does not mean that you have a veto. The definition of substantial control is a 4-part multi-factor test, and it was intended to be overly broad. It was intentionally over-inclusive because, remember, the Corporate Transparency Act is an anti-money laundering law. Congress and the regulators have assumed that there are bad actors that are going to try to get around this requirement. So they intentionally try to create these categories of control to sweep into beneficial ownership reporting anyone who might possibly have the ability to exercise control over the company in a manner that might lead to money laundering. So you are a beneficial owner by virtue of substantial control if you are a senior officer of the reporting company. Senior officer is defined as any individual that is the CEO, COO, Chief Financial Officer, General Counsel, or any other person who serves a similar function regardless of their actual title. So titles are important, but they're not determinative. If a person acts like a CEO, they are a CEO, and therefore they're a beneficial owner and need to be included. Subsection B. We also must include as a beneficial owner any individual who has authority over the appointment or removal of any senior officer or a majority of the board. That could be a lot of people. And subsection C, I think, is going to be the broadest of all. We include anyone who directs, determines, or has substantial influence over important decisions, including any one of the 7 non-exclusive examples provided below. So, who has substantial influence over important decisions? Well, in the case of a corporation, I think that every member of the board of directors has substantial influence over important decisions because they all get to vote, they all get to be present, they all get to have information about the board's decision. Here, be careful, there is an FAQ on FinCEN's website that asks, in essence, is it true that every member of a corporation's board of directors needs to be included as a beneficial owner? And the answer they give is true but misleading. FinCEN's answer is no, but if they have substantial influence over important decisions, they need to be included. As a corporate lawyer, I can't imagine a situation where a member of a corporation's board of directors does not have substantial influence over important decisions. So absent some extraordinary circumstance that I can't imagine, I believe that every member of a corporation's board of directors is a beneficial owner by virtue of subsection C. In the LLC context, subsection C also plays a role. Imagine, if you will, an LLC that has 5 equal members, each has 20%. So on the basis of ownership percentage, none of them is a beneficial owner, okay? Now, imagine that any major decision requires the affirmative vote of a majority of those 5 members. Well, by virtue of their voting rights, each of the 5 members now has, I believe, substantial influence over important decisions, so all 5 of them would be beneficial owners, even though none of them has more than 25%. And finally, subsection D is the catch-all. An individual is a beneficial owner if they have any other form of substantial control over the reporting company. This is what I call the Tony Soprano test. If you remember from the Tony Soprano television show, there was an Italian restaurant there. Tony Soprano, the mob boss, he didn't own the restaurant. His name wasn't in any of the paperwork, but he had a key to the place, and he could take money out of the till, and he could come and go at all hours of the day and night, and he would sometimes hold meetings there as if he owned the place. On those facts, if that restaurant was a reporting company, I think that Tony Soprano would fall under subsection D as a person who would be a beneficial owner by virtue of their other form of substantial control. And I think that's exactly the sort of factual scenario that FinCEN was getting at when they made up this regulation. So for each reporting company, we have a decision tree. Is it a reporting company? If so, is it exempt? If it's exempt, it doesn't need to file. If it is exempt and it's a foreign pooled investment vehicle, a very specific kind of thing, there is a special disclosure rule. Crack open the regulations and find out what it is. But except for those, if it's not exempt, it needs to report. So we first go through our calculations to figure out who owns 25% or more. Then we add to that list everyone who is a beneficial owner by virtue of substantial control. All of those people collectively are all of our beneficial owners, and for them, they're all going to need to be covered by the report. If our entity was created before this year, we don't care about company applicants. If it was created on or after January 1, 2024, we must also list the company applicant and provide their information. The information required in the report itself for the reporting company is going to include its legal name, any trade names or DBAs it has, a current street address for its principal place of business, its jurisdiction of formation, and its taxpayer identification number, or EIN. For each beneficial owner, we must include the legal name, the date of birth, residential address, and then a unique identifying number, which could be the driver's license or the passport, and then an image of the document that provides that unique identifying number. For each company applicant, we need the exact same information, provided, however, that a company applicant that is in the business of forming entities may provide a business address in lieu of a residential address. So here I'm going to stop for just a moment. As a practical matter, if you're in the business of managing numerous companies, how do you keep track of all this data? And remember the 30-day rule? After we file for the first time, if anyone's residential address should change, or if they get a new driver's license, that's an event that triggers the need for the reporting company to amend its report within 30 calendar days. How do you keep track of all that? Well, that is one of the benefits that my company's software does at fincenreport.com. We give you the ability to keep track of all that information, and if any individual keys in a change to their identifying information, we flag every single reporting company that they're connected to, that reporting company needs to file an amendment, and that amendment can be filed automatically through our system. So that's one of the key benefits that we provide in our software, and that's one of the reasons why we exist. If you're interested, you can click on the link that is in the chat to request a demonstration. If you're ready to get started, you can just go to fincenreport.com, click on the Get Started button in the upper right-hand corner. We're going to ask you for your name and email address, and that is going to create your personal account. Your personal account is free. We're never going to charge you for creating a personal account, but that will give you the opportunity to go in and sort of play around with the software and see how it works. If you're with a law firm and you want to work with us, we can actually create for you a law firm dashboard that will allow you to see all of the companies that you're working with and all of your colleagues at the firm. They all get listed inside the Companies tab. You have the ability to click on each one and then explore and keep track of the identifying information for the company. You can also then connect to the other members of the company, connecting through their emails so that they can keep their personal information separate and confidential, and make it all available for the report when it gets filed. When the report gets filed, we charge the reporting company a 1-year subscription fee of $199, but all the individuals are free. The attorneys and the accountants that are connected for advice purposes are all free. It's just a $199 per year subscription to the reporting company itself. If any amendment comes up during the year of service, that amendment is included at no additional charge, and the amendment can be filed with a press of a button inside our system. So I'm supposed to pause now for Jeremy to ask his other poll question.
Yep, thank you, Jonathan. One more poll question just to see if everyone was paying attention to see which rule requires this reporting. Take a couple of seconds here because we've got some more good content to get to. Quick question, Jonathan, while people are taking the poll. Another question about exemption. Actually, there's quite a lot, but this one was the first one, and I actually got an email asking about it as well, and wanted to know if nonprofits are exempt.
Absolutely, there is an exemption for nonprofits, but there are 3 types of nonprofits exempted, and there are other types of nonprofits that are not exempted. The largest exempt category are those that are exempt under Section 501c. So most of your churches and charitable organizations under Internal Revenue Code Section 501c will be exempt. Homeowner associations, community associations, however, are exempt under IRC Section 528, and 528 is not covered by the CTA exemption for tax-exempt entities. So community associations, even if they're organized as nonprofit corporations under state law, if they are exempt from taxation under Section 528, they are not exempt from the CTA, and they will need to file.
All right, thank you. 91% got it right, CTA. 6% say the AML Act. That's actually, I'll mention that briefly at the end, and we'll be having another webinar coming up that will educate everyone about what those requirements are. So back to you, Jonathan.
You bet. So let's go through some examples here. Now, example 1 is the easy one. Larry, Bill, and Sally form an LLC. They each contribute $1,000. They each get 1,000 units. The operating agreement says that distributions are made first to the members in proportion to their unreturned capital, and thereafter to the members in proportion to their beneficial ownership interest. So who are the beneficial owners? That's easy. It's Larry, Bill, and Sally. Each has 33% of both the capital and the profits interest. If the LLC were liquidated, whether it was for $1 or for $1 billion, they would each get more than 25%. So they are all beneficial owners by virtue of ownership percentage. Is this answer reasonably certain? Yes, it doesn't matter what the liquidation value is. Therefore, each of them is a beneficial owner. Now, let's get more complicated. Let's say we have a reporting company that has 3 members in it. Each of the 3 is a different LLC: Property Co., Developer Co., and Investor Co. Let's say Property Co. contributes real property with a value of $5 million. Investor Co. contributes cash of $5 million, and Developer Co. does not contribute any cash, but it puts the deal together. In the first level of our waterfall, Property Co. and Investor Co. split distributions 50-50 until each gets a return of their contributed capital. In the second level of the waterfall, Developer gets 100% of the next $1 million. Thereafter, everything is split 25% to the Property Co., 25% to Developer, and 50% to Investor Co. Ignoring substantial control, so just looking at beneficial ownership, who is a beneficial owner? Well, this is a great example of when the partnership capital rule does not lead to a reasonably definite outcome. We don't know what percentage everybody's going to get until we know the liquidation value of this thing. So we can't just make a guess at it. We have to go to the fail-safe rule. The fail-safe rule says that you're a beneficial owner if you have more than 25% of any class or type. In this case, Property Co. and Investor Co. each have 50% of the first level of waterfall. Developer Co. has 100% of the second level. Now at the third level, it's split 25, 25, 50. So each of these 3 entities would be a beneficial owner. But we don't report entities unless they're exempt. And in this case, we're assuming they're not exempt. So we're going to have to look up the ladder to see who are the indirect beneficial owners that need to be reported with respect to reporting company. Well, let's imagine in this case that Property Co. is owned by 5 individuals, each of whom has an equal 20% stake in Property Co. Now remember, Property Co. has 50% of one class and 25% of another class, purely on the basis of ownership, with each individual having an indirect 10%, which is 20% and 50%, right? That's less than 25%. So in that case, solely on the basis of ownership, none of those 5 individuals would be a beneficial owner. None of them would need to be counted as a reporting company, as a beneficial owner of a reporting company. But remember, this is only on the basis of ownership. We haven't talked about substantial control yet. Let's imagine in this case, how would we figure out whether any of these 5 individuals have substantial control? Well, we would want to examine the operating agreement of Property Co. to see how they vote. Is there a manager or a board of managers who has control? Is there a CEO or a senior officer of Property Co. who might have substantial control over a reporting company as a result? Ultimately, we don't have enough information right now to know whether any of these 5 individuals would need to be covered as a beneficial owner of a reporting company, because we don't know enough about the operating agreement of Property Co. and Reporting Co. to know who has substantial control. Depending on what the language in those documents, it's possible that all 5 are, it's possible that none of the 5 are. Let's imagine we take the same waterfall as we just did, and in this case, the reporting company, operating company, Developer Co. is the manager. But any major decision requires the consent of both Property Co. and Investor Co. So our ownership analysis is the same as before, but the substantial control analysis is different. Any individual with substantial control over Property Co. is going to have substantial control over Reporting Co. because it's going to have a vote. Any individual with substantial control over Investor Corp. will also have substantial control over a reporting company. Unfortunately, FinCEN doesn't give us a whole lot of guidance. FinCEN's FAQs don't cover this. They also have a publication called the Small Entity Compliance Guide. It does not address complex situations like this. So in my view, you want to be conservative, because if you are over-inclusive in including people, that's okay. That won't get you in trouble. But if you exclude people that FinCEN later determines should have been included, that could be a misstatement. That could potentially put someone on the hook for criminal sanctions if that decision was made willfully. So in the situation where these individuals are voting at the Property Co. level, I would say that they do have substantial control. And in this case, because Property Co. has effectively a veto over reporting company decisions, each of those 5 individuals, I think, ought to be counted as beneficial owners at the reporting company level. In this case, let's imagine that Property Co., with our 5 equal members, is a member-managed LLC with all decisions requiring a majority vote of the 5. Well, that makes this really easy. In that case, I apply what I call the transitive power of substantial control. Since Property Co. has substantial control over Reporting Co. by virtue of that voting provision we just talked about, and each of these 5 individuals gets to vote at Property Co., in that case, I think it's pretty clear, each of the 5 individuals would be a beneficial owner of a reporting company. Now, in this case, let's imagine that we're looking up the Investor Corp side of the chain. Facts are still the same. Both Property Co. and Investor Co. get to vote on major decisions at the reporting company level. But in this case, the investment advisor is an exempt entity. Good news. In that case, Investor Corp it's sufficient for us to simply identify the name of Investment Corp because it is a REIT. If it were not a REIT and it was under the management of a registered investment advisor, then that would be the entity with substantial control. We would list the name of the registered investment advisor. Registered investment advisors is another category of exemption in the regulations. So that's how that one would get covered. So let's get a little crazy. Same facts as before, down at the reporting company level. In this case, Property Co. is going to be owned by 4 individuals who have 20% each. And then Robert Biggs, Mr. Biggs, he also owns 20% of Reporting Co. Robert Biggs is also the manager both of the Developer Co. and of the Investor Co., which in this case is a non-exempt reporting company. And so the question is, who are all the beneficial owners of reporting company and why? Well, when you break it all down, Robert Biggs is going to be a beneficial owner because his percentage interest is going to be greater than 25%. He is also going to have substantial control by virtue of his management roles, both at Property Co. and at Developer Co. and at Investor Co. The 4 individual members of Property Co. are also going to be beneficial owners by virtue of their substantial control because of the voting that we described last time. And the 9 individuals of Developer Co. Could very well also be members who have substantial control to the extent that Developer Co. is going to get a vote on important decisions at the reporting company level, and they would get to participate in that vote. So as you can see, reporting company, in order to get the answer right, not only has to have its own operating agreement in front of it, it's going to have to inquire of Investor Co., Developer Co., and Property Co., and sometimes even farther up the chain than that, to see who is in control of each of those entities in order to apply the substantial control test correctly. Would it matter if Robert Biggs put all of his interests in a trust? The answer is we would have to apply the trust rule. Again, we're sort of skipping over that, but depending on the structure of the trust, either the trustee, the beneficiary, or the grantor of that trust would be the person that we would report with respect to the interests of Robert Biggs if his interests were in a trust. Would it make a difference if Investor Co. had an operating agreement with a member vote provision? In other words, if there's ever any major decisions, all the members have to vote, including the 100 individuals that have 1% each? Yes. I think that if there was that kind of a voting provision in Investor Co., quite possibly all 100 individuals might need to be included as beneficial owners because of their vote. And finally, would it matter if reporting company had a CEO and a CFO? Yes, it would. Those individuals would be senior officers, and we would need to include them under the substantial control test. And I think this is our last hypothetical. Oh, no, I got 2 more. In a Section 1031 transaction, again, I'm a corporate lawyer by practice. I'm not a real estate lawyer, so I've only dealt with 1031s a few times. My understanding is that we have some really strict timing rules involved in a Section 1031 exchange. When the selling individual is selling property, they have 45 days to identify a new property and then 180 days to close. Very often there's an exchange accommodation title holder entity that needs to get formed, and then there's going to be a transaction within 90 days. Depending on the timing, for example, you did one in 2024, that 90 days is going to pass before we actually get to the closing of the 1031. In that case, the exchange accommodation title holder is probably going to have to file an initial BOI report identifying as the beneficial owner whoever it is that owns it at that time. And then after the closing of the 1031, when the relinquishing property owner takes ownership of the exchange accommodation title holder, that entity is going to have to file an amendment to its BOI report to reflect the change in ownership, the exit of the exchange accommodation title holder, and the insertion of the new client that now owns the EAT LLC. Things can get pretty hairy when we're dealing with opportunity zone transactions. I've been involved in a handful of these, again, from the corporate side of things. As many of you probably know, in an opportunity zone transaction, we often have a fund entity that accumulates all of the investors who have qualified rollover gain that want to get the benefits of the opportunity zone investment. We put them into a qualified opportunity zone fund, or QOF, in order to satisfy the rules. The Property Co. at the bottom has to satisfy all of the requirements for a qualified opportunity zone business. It has to have a certain amount invested at certain points in time that represent improvements to the real property that's located inside the opportunity zone. Very often the way that comes out is in the operating agreement, both at the QOF level and at the QOZB level, where there's a list of requirements that the LLC always has to abide by in order to ensure that the structure satisfies all the OZ rules, so that the QOF fund investors get the benefit of the bargain with the preferred tax treatment. And very often those operating agreements say, we're going to do it this way according to these rules, and the only way we can do it otherwise is if we have a vote of either all of a supermajority of the fund investors in the QOF. It's that sort of voting provision that very well could trigger a substantial control analysis that would force us to have to identify all of the QOF fund investors as beneficial owners of Property Co., even though their ownership is going to be much less than 25%. By virtue of that voting provision, they could have substantial control over major decisions, and for that reason be beneficial owners. So something to watch out for in your OZ fund and your opportunity zone transactions. That gets me to the end. And Jeremy, I'm sure we have a lot of questions. I don't know that we'll be able to get to all of them today, but go ahead and give it a shot. And why don't you tell me which are the ones that you think would be the most helpful?
All right, yeah, definitely. Thanks, Jonathan. And you're right, we have got many during the course of your presentation. And there are a lot of different flavors of the scenarios. I'm not sure I'll pitch all of those to you. Jonathan's contact information is on the screen, on the slide there. So if we don't answer your scenario, I encourage you to reach out to him. But we've got a little under 10 minutes, so we'll see what we can knock out here.
Yeah.
Kind of more of a general question, Jonathan. A couple people have asked, is there a problem if you report a BOI, file a BOI report if you're not required to do so?
Absolutely not. It is completely fine. In other words, if a reporting company might be exempt, but we're not really sure, the prudent thing to do is go ahead and file.
Mm-hmm.
Similarly, if you have a handful of potential beneficial owners and you're not sure if they all need to be included, err on the side of over-inclusiveness. There is no penalty for being over-inclusive, but excluding someone could be a felony. So yeah, that tells you which way to
go. What if the individual who filed is no longer with that company or entity? What should a company do then?
So that question tells me that this person is confused about what the company applicant is and when we need to provide it. That's because back in 2021, there was an earlier version of the regulations that would have required every reporting company to provide its company applicant. Obviously, that was kind of silly because we have entities that are 100 years old. Company applicants have been dead for a long time. If the entity was formed before January 1, 2024, you don't need to disclose the company applicant. You don't need to figure out who filed the articles. The only time you need to have the company applicant is for new entities beginning in 2024 and heading onwards.
All right, good clarification, because we had a few others said, what if the original person can't be found? So formed before 2024, January 1st, 2024, you're good.
Doesn't matter. Yeah.
All right. Maybe a question to clarify a little bit on sole proprietor. What if any LLC that is a sole proprietor, are they exempt?
When someone said sole proprietor, that means it's a natural human being and they do business through their own social security number. They do not have a corporation or LLC. That's a sole proprietor. An LLC that has only one member is a reporting company. All LLCs, all corporations are reporting companies. The only question is whether or not they're exempt.
Okay. Definitely a burning question that we've got, and you touched on it. I asked, if you could clarify, an insurance company if they're exempt. People are, majority of the people on the call are title agents. They're title agencies, however they're licensed in their state. Title insurance underwriters, attorneys, settlement agents, a lot of different flavors and a lot of different how they're, what they're called in each state. But Jonathan, maybe if you could talk a little bit more on, if you are a licensed agent in a state, would you be exempt? Would you be considered a title company?
And the answer is, I just don't know enough about the regulatory status of title companies. The insurance companies have one particular form of exemption. There is also an exemption for a state licensed insurance producer. And I'll just read the regulation to you. I don't know what any of this stuff means. An entity that is an insurance producer that is authorized by its state and subject to supervision by the insurance commissioner or similar official or agency of a state, and has an operating presence at a physical office within the United States. That entity is exempt.
Okay.
So
Well, yeah, that
folks need
seems
to talk to their regulatory counsel. Yeah.
yeah, but that seems spot on. So, Jim and others who pose that question, does a state licensed insurance producer exemption include a title agency? And, it sounds like yes. All right. Well, we kind of knocked out that, but that was the majority of the questions that was on people's minds. Let's see here. When a report is filed, who has access to that information? Is it just FinCEN or do other entities have access to that?
Great question. Great question. So there are 3 rulemakings that FinCEN needs to complete. They've only completed one, and that's the one that tells us how to file reports. They have done a first draft of the access rule, which is the rule by which people will get access to BOI reports. There are 5 different categories of entities that can get access. Generally speaking, they are banks and financial institutions, but only with the permission of the company. Then there are Treasury Department employees. That's the IRS, guys. Then there are other federal government employees, which include all of your federal law enforcement agencies, ATF, DEA, FBI, DOJ. Then there can be state law enforcement. And then there's foreign governments in some situations. There's a different rubric of control and permissions for each of those 5 different categories. They're all quite complicated, and none of them are final yet. As you can imagine, each one of the 5 categories has advocates that are arguing that it's easier for them to get access. The banks, for example, want to be able to get this information easily, and yet FinCEN has a statutory duty to keep the data confidential. Generally speaking, none of this information is available to the public. It is not subject to a FOIA request. FinCEN cannot be compelled to disclose it through a subpoena. Only those 5 categories can get to it. So there would be a whole separate seminar to talk about the access rule and where it is and where it might go.
Okay. There was a really good one here. I'm trying to find it in this list that's popping in quickly. Here it is. And I'll try to break it down here. If the legal name of a company in another country is ABC Company, for example, but you had to register in the US adding an Inc. or a Corp to its name, do you file under its original name or what it's now called in the United States?
Ooh, that's interesting. That's interesting. Well, the regulations say that the reporting company has to provide its full legal name. I suspect that when the entity filed to do business in whatever state, it had to say that whatever the name it put down was its full legal name. So my guess would be the name that was used in the Secretary of State's office when they filed whatever they filed.
Okay. All right. Well, we're at the top of the hour. A lot of great questions. I'm not sure if we definitely, solved the title insurance producer exemption question completely, as each state may handle it differently. So as Jonathan said, definitely, have a discussion with your counsel and make sure what you need to do or not to do. We'll compile these questions and we'll get an FAQ together to, help guide everyone. There's also last week, I think some of the questions I was getting, in addition to this rule, last week FinCEN also released a proposed rule for, its AML rule that's going to require title and settlement, agents to report information to FinCEN about all cash residential transactions nationwide involving, legal entities. So basically think, geographic targeting orders across the country. We just got the rule last week, so we're really starting to dig into it. We'll have a webinar coming up, to help educate everyone and help understand what you need to do as far as data collection from your customers. So stay tuned for that. If you missed parts of today's webinar or think of others in your office would benefit from listening, a recording of the presentation will be available at alta.org/webinars. You also get a link tomorrow. You'll get an email with a link to the recording and a link to get a copy of Jonathan's presentation. I pasted the instructions in how to get your CE or CLE credit in the chat box. You'll also get an email tomorrow with a follow-up on how to do that as well. So don't sweat. Need to thank Certified once again for sponsoring today's webinar. Jonathan, thank you for taking some time to help everyone understand what this BOI FinCEN reporting rule requires.
You bet. Thank you for the opportunity. And as I mentioned, if anyone would like a demonstration of the software, please click the link. We're also going to have a reporting tool for the new real estate reports when that rule is finalized. So check out our website and follow us on LinkedIn if you want to stay apprised of what we're doing there.
Okay. All right. Thank you very much. That brings us to the conclusion of today's presentation. Take care, everyone.